Hey everyone, welcome back for another deep dive with us. Today's topic is something I think we can all relate to, at least a little bit. It's about what happens to employees, their hard-earned money like pensions and gratuities. When the company they work for, well, let's just say it hits a rough patch, financially speaking. It's a situation that unfortunately impacts a lot of people. And it raises some serious questions about fairness, about corporate responsibility. And here's the thing. It's not just about the employees. This whole issue also has a big impact on a company's ability to get back on its feet, especially in a place like India, where attracting investors is so crucial for growth. So to help us untangle this knotty problem, we've got some incredible legal analysis to dig into from some of the sharpest minds in Indian corporate law. And they're all laser-focused on something called the Insolvency and Bankruptcy Code, or IDC for short. Think of it as the rule book for when companies face financial distress. And let me tell you, it's got more twists and turns than a Bollywood thriller. So are you ready to dive in?
Absolutely, and I think it's important to start by understanding the context here. The IBC was actually created to bring some order to what used to be a very chaotic and unpredictable process. Before the IDC came into play, insolvency proceedings in India, well, they could drag on for years, leaving everyone involved, especially the employees, in a really tough spot.
So it's about bringing some method to the madness, so to speak. But how exactly does it work, this IBC?
Right. So at the heart of the IBC is this thing called the waterfall mechanism. Now, before you picture a literal waterfall, it's more of a way to visualize how a company's debts are paid off during insolvency. Imagine a cascade of water flowing down in a specific order. That's kind of how the waterfall mechanism works in the IBC. Specifically, under Section 53, it lays out the pecking order, so to speak. Certain debts, like those owed to secured creditors, they're at the top of the waterfall. They get paid first because they have assets backing up their claims. Then you have other types of creditors, like unsecured creditors, further down the line. And that includes employees, unfortunately.
Okay, so there's a hierarchy, a pecking order of who gets paid first if a company goes under. And this waterfall mechanism, it was designed to speed things up, right?
Exactly. You see, before the IBC, studies showed that it took an average of 4 years to resolve insolvency cases in India. Can you imagine the uncertainty, the stress of waiting that long? But with the IBC, the goal is to resolve these cases much faster, ideally within a year. And a faster resolution is better for everyone. Creditors can recover their money more quickly, and companies, well, they have a fighting chance to restructure and get back on their feet.
Makes sense. A faster resolution is better for everyone in the long run. But where do employee dues fit into this whole waterfall system? Are they considered a high priority?
That's the million-dollar question, and this is where the IBC tries to strike a very delicate balance. On one hand, you want to make sure that employees are protected, especially since their livelihoods are on the line. But on the other hand, you don't want to discourage investors from coming in and trying to rescue struggling businesses. It's a real balancing act. So the IBC tries to find that sweet spot. It acknowledges that employee dues are important, but it also has to ensure that there's something left for other creditors and potential investors. And that's where the details of how employee funds are actually managed, well, that's where things get really interesting. And that's what we'll unpack in our next segment.
Okay, so we've got this waterfall mechanism. We've got employee dues trying to find their place in the flow. And we've got this delicate balancing act between protecting workers and keeping the economy afloat. It's getting juicy, folks. Stay tuned as we dive deeper into how the IBC tackles this complex issue of employee funds in our next segment. All right, we're back and ready to wade even deeper into this whole IBC labyrinth we found ourselves in. Last time we were talking about the waterfall mechanism and how it prioritizes different debts when a company in India goes belly up. But we left off on kind of a cliffhanger, didn't we? Talking about how employee funds, those pensions, and gratuities, well, they're kind of a special case in this whole system. And our legal experts, they dug into the nitty-gritty. And it turns out a lot hinges on how these funds are actually managed. So can you walk us through that, break it down for us? How does the way these funds are handled affect what happens to them when a company goes under?
Absolutely. And sometimes using a real world example can help make things clearer. So let's say we're talking about a big manufacturing company, right? Now, this company, they've got a couple of options for managing their employee pension funds. They could choose to manage it all themselves in-house, as they say, basically keeping the money within the company, investing it how they see fit. Or they could go with an external provident fund, something like what the EPFO, the Employees Provident Fund Organization, manages here in India.
Okay, so two different approaches, but what's the big difference in the eyes of the IBC? Why does it matter who's managing the money?
Well, it all boils down to control, to who has access to those funds, especially when a company is in distress. You see, when a company manages its own funds, That money, even though it's meant for employees, it's still considered part of the company's assets.
Oh, I see. So it's like, even though it's earmarked for the employees, it's still technically the company's money.
Exactly. And that means if the company goes belly up, those funds, well, they're up for grabs, so to speak, along with everything else.
So in that scenario, what kind of protection do employees actually have under the IBC?
Well, that's where Section 36 of the IBC comes in. It's a bit of a mouthful, but essentially it tries to create a safety net for employees.
A safety net, so there's some hope.
Some hope, yes, but it's not always straightforward. This section basically says that if those employee funds, if they're clearly identifiable, they haven't been mixed with the company's general funds, then they should be used to pay off those employee dues.
So it's like trying to follow the money trail, making sure it hasn't gotten lost in the shuffle.
Precisely. But now let's flip the script and look at the other scenario, where those employee funds are managed externally by someone like the EPFO. In this case, the IBC sees things a bit differently. Because those funds aren't directly controlled by the company, they're not automatically lumped in with the company's assets during insolvency.
So it's like the company doesn't own that money anymore. The EPFO does.
Right, and that means employees, well, they become like any other unsecured creditor.
So they have to wait in line, so to speak, hoping there's enough left in the pot at the end of the day.
It's not an ideal situation, and unfortunately, as we saw with the Kiran Udyog case, there's often not enough to go around.
Right, because even though Kiran Udyog had settled directly with their employees, the EPFO was still left holding the bag with a huge outstanding claim.
It shows how messy and complex these situations can get, with all these different parties and interests all vying for a piece of a shrinking pie.
And I'm guessing this is where those legal cases you mentioned come into play, the ones trying to make sense of it all.
Exactly. Cases like the State Bank of India versus Moser Bear and Sunil Kumar Jain versus Sundaresh Pat, they highlight the tension that exists between trying to protect employee dues and attracting investors at the same time.
Okay, hold on. Investors, you mean like those white knights who come in and rescue struggling companies?
Yeah, you could call them that. In the IBC world, they're officially known as resolution applicants.
Resolution applicants, got it. But why is there tension with them? Don't they want to help the employees too?
They do, ideally, but they also want a clean slate, a fresh start without being bogged down by all the past debts and liabilities.
And that's where that clean slate principle comes in, right? The idea of giving a company a fresh start.
Exactly, but the big question is, how do you balance that with making sure employees aren't left high and dry?
Right, because their livelihoods are at stake.
It's a tough question, and as you can imagine, it's led to some pretty fascinating legal battles.
All right, so we've gone down this rabbit hole, explored this IBC maze, and it seems like we've uncovered two basic scenarios when it comes to employee funds. And I know our listeners are probably thinking, okay, enough legal jargon. What does this actually mean for me and my paycheck? So let's break it down. First, we've got companies managing those funds themselves, keeping the money, in-house. And in this case, if the company goes under, the IBC tries to protect those funds, but like we've seen, no guarantees.
Exactly. Think of it like this. The IBC, it sets up a sort of safeguard saying those employee funds, they should be used to cover employee dues. But, and this is a big but, only if those funds are still there, haven't been touched, haven't been mixed in with the company's general accounts.
So transparency is key here, right? Employees need to know how their company handles their money. Now, the other scenario, and this is where it gets even trickier, is when those funds are managed externally, like with the EPFO.
Right, because in those cases, the employees, they're basically at the mercy of the IBC's waterfall.
And hoping there's enough water left at the bottom.
Exactly, and that's where those legal battles we talked about, the Moser Bear case, the Sundaresh Pat case, they become really important because they highlight how tricky it can be to balance attracting those resolution applicants, the ones who are supposed to swoop in and save the day.
Our corporate superheroes.
Right, but also making sure that employees aren't left holding an empty bag.
Because let's be real, those employees, they're the backbone of the company. They deserve to be protected.
Absolutely, and that's what makes this whole area of law so fascinating, so complex. It's about finding that balance, protecting workers' rights while also creating an environment where businesses can thrive.
It's a delicate dance, isn't it?
It really is, and these cases, they show us that there's no easy answer, no one-size-fits-all solution.
So what's the takeaway for our listeners? What can they do to protect themselves?
Well, knowledge is power, right? Understanding how the system works, even the basics, can make a big difference.
Absolutely, and I think this deep dive has really highlighted that. Sometimes the law, it can feel like this big, mysterious thing,
It can feel very distant,
but it affects all of us, whether we realize it or not.
especially when it comes to something as important as our livelihoods.
So, dear listener, as you're navigating your own career, remember that staying informed, asking questions, it's crucial. You have the right to understand how your hard-earned money is being managed. And who knows, maybe, just maybe, by shedding light on these complex issues, we can start to create a system that's fairer, more transparent, and more equitable for everyone. And that's a goal worth striving for, wouldn't you say?
Absolutely, a goal worth striving for.
Well, on that note, folks, we've reached the end of another deep dive. Thanks for joining us as we explore the ins and outs of employee dues in corporate insolvency. It's been real, and we'll catch you next time for another adventure into the world of, well, something equally fascinating. Until then, stay curious.